Hi everyone. Welcome to TrainHR's live webinar on the interactive process and accommodation of the disabled under the ADA. My name is Liz and I'm going to be your host today. On behalf of TrainHR team, I would like to thank you for being part of this event. Today's webinar will be presented by Susan Fahey Desmond. Susan is a shareholder with the firm of Jackson Lewis LLP, which has offices in 59 cities across the country. She has been representing management in the area of labor and employment law since her graduation from the University of Tennessee School of Law. Susan is a frequent speaker and author on a number of labor and employment issues. She's named in Best Lawyer in America and has been named by Chambers USA as one of the America's leading business lawyers for labor and employment law. We are honored to have such a distinguished person such as Susan with us to present this webinar. Ladies and gentlemen, before we begin, I would like to inform you of the program outline for this training session. This webinar is for 90-minute duration. First, Susan will take you through today's webinar, highlighting the area that will be covered, and she would then share with you her presentation. I would also like to inform you that all participants, once they're part of teleconference, have been placed on mute and will remain so until the Q&A begins towards the end of this webinar. This is for the purpose of avoiding discontinuity and for allowing the presenter to speak clearly so that everyone present can take maximum benefit from this webinar. I also request all to hold back your question until the Q&A window begins. 10 minutes of time will be allotted for the Q&A, during which your questions will be answered. And if for any reason, ladies and gentlemen, you get logged out of this training session or teleconference, I request you to follow the same procedure to join in again. Now that we are all ready to start, I request Susan to take it from here. Susan.
Thank you, Liz. As Liz said, for the next 90 minutes or so, we are going to be talking about the interactive and accommodation process under the ADA. As you will see throughout the presentation, when the ADA was first passed for various reasons, we rarely ever actually got to the question about reasonable accommodation or the interactive process. In large part because the ADA was being construed so strictly that courts were finding a difficult time finding people who were actually covered by the ADA, and therefore an accommodation may or may not be required because they had a disability that would be covered by the ADA. But with the new amendments to the statute that we will be talking about a little bit, but not quite as extensively, but discussing how they impact why we are looking more at the interactive and the accommodation process. We will be discussing how the new amendments do require a lower interpretation or lower standard by which to determine who meets the definition of disability. And with that lower standard that's being used, as we have, it results in we have a number of people who would meet the definition of disability that they would not have met this definition in years past, and therefore we are now getting more into the interactive and the accommodation process. So we go through here. Let's just talk about what is a disability, and I think that, this is a definition that, contrary to popular belief, did not change in the new law. But we always had a definition of a disability, and when it was being construed when the ADA was first passed, it was being construed so strictly that what we found were a number of people just did not meet the definition of disability, and therefore we did not get to the issue of the interactive or reasonable accommodation process. A lot of people talk in terms of the disability definition being changed with the Amendments Act, and that's not the case. What happened is the definition didn't change, but what Congress said to employers and to courts is that we are going to interpret this definition with a less exacting standard than was being used by the courts under the original passage of the ADA. So as I said, the definition hasn't changed. It is still considered a physical or mental impairment that substantially limits one or more major life activities. Also includes a record of a physical or mental impairment that substantially limits one or more major life activities but may not be active. For example, someone who may have had a history of cancer but they're now in remission, they would meet that second criteria. And also would include one who is regarded as having a physical or mental impairment that substantially limits a major life activity. On the regarded as aspect, what we are looking at are individuals who do not have this physical or mental impairment, but that the employer perceives that they do and treats them as such. And those are a little bit more difficult situations to follow because, you know, you get into the question is, do you really have to accommodate a mental or physical impairment that doesn't result in a disability merely because the employer has regarded them as being so? And it is kind of counterintuitive to think in those terms. But clearly when we talk about someone who has an active physical or mental impairment with that substantial limitation, or someone who has a record of that physical or mental impairment, clearly we get into the question of interactive process and reasonable accommodation requirements that may be necessary in dealing with that particular individual. Now, with this less exacting standard, what we had was Congress actually reversing a set of U.S. Supreme Court cases that had held that certain conditions did not meet the definition of disability because they were not too limiting, they were not limiting enough, or the Supreme Court had held that there were certain impairments that were not disabilities because there were mitigating measures that could be used to eliminate or to alleviate the impairments that would be caused by the limitations that would be caused by the impairment. And so when Congress passed the amendments to the Disabilities Act, they said that the definition is no longer going to be subjected to this exacting standard and that mitigating measures will be considered. Just to give you a little bit of a history on that, that actually resulted in a set of Supreme Court cases. The exacting standard case actually came out of an assembly line position where the individual was working on an assembly line and she had developed severe carpal tunnel syndrome, and so much that she had been unable to perform her job for her employer because of the carpal tunnel syndrome. But when it went up to the Supreme Court, despite the fact that there were severe limitations that made her incapable of performing the job with her employer, the court said, well, she still does not meet the definition of disability because we have to use this exacting standard. So we're looking at, you know, how the impairment affects her everyday life, not just how it affects her at work, but in her everyday life. And the court noted that she was able to shop and she was able to comb her child's hair and drive and do the things that a lot of us do in our everyday lives, and therefore found that she was not disabled. And, of course, if she's not disabled, we don't get to the question about an interactive process or the accommodation because there's no need to, because they're not covered under the ADA. The second case that was being addressed by Congress when it passed the amendments was a case that dealt with two sisters who had severe myopia, and they had applied for a pilot position with United Airlines, and these individuals were legally blind without the benefit of their eyeglasses. But if they wore their eyeglasses, they were pretty close to a 20/20 vision. United Airlines did not have a policy of an absolute 20/20 vision requirement, but it was pretty close. And so they met the requirements of the position as long as they wore their glasses, but they obviously did not meet the requirements if they were not wearing their glasses because they were legally blind without the use of those glasses. And the Supreme Court, in looking at it, said, well, in determining whether someone is disabled under the statute, we look at how limiting would their impairments be without the benefit of these mitigating measures, such as eyeglasses. And of course, that thought process bled over into things like medication for diabetes, diabetes that can be controlled with medication, or any other condition that might be controlled by medication or by even surgical intervention or the like. And so we don't no longer look at that. And after the Congress passed the Amendments Act and lowered these standards, the EEOC came out with came out with regulations that were and still are controversial, and because according to the EEOC, they felt that some impairments would be virtually always a disability. And the reason why that's been a little controversial is because the Congress in its legislative history and the courts that were interpreting the ADA before the amendments have always said that in determining whether someone indeed has a disability, you have to look at it on a case-by-case basis. Not every mental or physical condition, even with the same diagnosis, is necessarily substantially limiting, because every person is different in how they may react to these particular mental or physical conditions. And so that's been a little bit controversial, but with that said, you still have to deal with the EEOC's thought process that there are certain conditions that will always be considered a disability, or virtually always, and therefore the EEOC will most likely make you jump through the hoop of going directly to an interactive or an accommodation question without really truly addressing whether the individual actually has a disability and should